online ones. Are you all good?
All right. So, in a world where we actually started with the famous white collar crime and we moved to the evolution of the economic crime schemes, which is quite academic, which includes your cybercrime, it includes your fraud and other predicate offenses. And we then moved to what we call now, colloquially, the financial crime compliance, right? Today, we are here to make sure that all those terms that are often used interchangeably are relevant to us. Good morning, everyone. My name is Levarang, and I'm your host for today. And welcome to the Digital Assets and Sanctions Compliance Conference. Okay, so I will not obviously be talking alone today. There's quite a lot of esteemed speakers that are very much as passionate as I am about financial crime. You will enjoy today listening to their skills, listening to where they come from, listening to what exactly makes them passionate about financial crime. But most importantly, looking at the evolution of digital assets and sanctions compliance. So you will not only be bored by my voice today, but you will certainly enjoy what's coming forth for you today. Right. So we do have a couple of house rules. Every single house would have some rules. There is one particular mode that is not used on our phone, and that's the flight mode. Please let's utilize it today. But the only time that you don't have to utilize it, please just make sure that you do use the Endeavour Hotel Wi-Fi when you need it to please hashtag Umbono Conference and show the world really what it is that we are talking about today. It's not just about bringing speakers together, but it's also about talking about what really is engraved in our country at this point and what is hot topic for us. Please do let the world know what it is that we're engaging about today. Okay. If you do feel that you need a couple of comfort breaks, there is the ladies and the gents at the outside. So that will be on your right, just up the stairs. And if it gets to a point where you really need to take a call, I'm happy that you do. Right. To the speakers, we have to really do keep time. All right. We did start a bit late, but please do keep to time. If I do this, it doesn't only mean that you are doing a great job, because you probably are doing a great job, but just means that we need to speed up a bit. Okay. But please, we do have a Q&A also for our virtual people. We will have a Q&A. It is an engaging session. We will give that platform. And please, today, just make sure that you sit back, but don't relax. Let's engage as much as possible and make sure that when we all leave here, we leave with the same passion of curbing financial crime, because I think that's why we're all here. All right. Without any further ado, I just want to make sure that Krevania is online. Please just confirm. All right. Our first speaker, thank you. Our first speaker, ladies and gentlemen, is a person that is known now for the term rather safe than be sanctioned. When I actually read the article, I thought, well, we usually use rather safe than sorry, but that is quite intriguing to know that, why do we need to be safe rather than be sanctioned? So Krevania Pillay is a senior associate at Cliff Decker Hoffmeyer, and she will be speaking to us about her title in the article, Rather Safe Than Sanctioned. Please give her a round of applause as she presents to us what she has in store for us today. Thank you.
Thank you so much for the introduction, Tanile, and thanks everybody for the opportunity to present today. I look forward to this inaugural event and being your speaker today. My aim is to speak to you a bit more about the South African sanctions framework and really what it comprises of. What is the law of the land when it comes to sanctions in South Africa? And more importantly, what are the recent developments that have occurred in the sanctions space, following on from FATF's mutual evaluation report. So these are the topics that I'll take you through in the next half hour, and at a high level, touching on the implications of the amendments to FICA, what they mean for South Africa, and tips to mitigating your risk with dealing with sanctioned individuals and entities. So as a starting point, what really are sanctions? The use of sanctions are somewhat of an economic weapon, and they've been a long and standard feature in international politics. The measures usually consist of economic, financial, or other restrictions or embargoes, and are designed and applied to incentivize change. What change? The change we're talking about today is change in behavior or policy to constrain prohibited activities and signaling opposition against a sanctioned target. So as an overview, today I will take you through recent amendments to the Financial Intelligence Center Act, a few international trends in the sanctions regulatory framework, as well as I mentioned earlier, tips for mitigating risk with sanctioned individuals and entities. Moving on to the next slide. As I touched on, it is indeed an economic weapon used in warplay, as we've seen in the recent war against Ukraine, where there have been sanctions imposed against Russia from various quarters. Moving on to the next slide. South Africa has developed and adopted various regulatory instruments to enable or enforce targeted financial sanctions in accordance with its obligations as a United Nations member state. South Africa's primary targeted financial sanctions compliance obligations are founded in the Council's resolutions themselves, being the UN SC resolutions, which bind South Africa as a United Nations member state and have been incorporated into our local legislation. The United Nations Security Council can take action to maintain or restore international peace and security under Chapter 7 of the United Nations Charter, thereby including sanctions measures, which have a broad range of enforcement options that do not critically involve the use of armed force. The secondary source of obligation originates from South Africa's membership to FATF, or the Financial Action Task Force, who, as I'm sure we all know, have recently grey-listed South Africa. The task force is an international standard-setting body that works to promote effective legal, regulatory, and operational measures to combat money laundering and the financing of terrorism. It does so through the issuance of its standards. FATF has 40 standards, 2 of which are relevant to the imposition of sanctions, and that is Recommendation 6, which pertains to targeted financial sanctions related to terrorism and terrorist financing, and Recommendation 7 that relates to non-proliferation related targeted financial sanctions. It requires countries to implement targeted financial sanctions to comply with their UNSC resolutions and to ensure that there are measures in place to prohibit transactions with sanctioned individuals and entities. Several laws have been promulgated in South Africa to enforce these sanctions obligations and incorporate them into our local framework. These are the Financial Intelligence Center Act and the Protection of Constitutional Democracy Against Terrorist and Related Activities Act. For today's purpose, I'll be talking to the Financial Intelligence Center Act, or commonly known as FICA, as well as the slight amendments that have been made to it to align South Africa with international sanctions standards. So moving on to the next slide. The Financial Intelligence Center Act was the primary legislative instrument that was promulgated in South Africa to incorporate anti-money laundering measures, as well as counter-financing of terrorism measures. It places a responsibility to administer targeted financial sanctions measures adopted by the United Nations Security Council in its resolutions. Sanctions impose restrictions on activities that relate to particular goods, services, persons, or entities. And the TFS, Targeted Financial Sanctions List, and the measures incorporated therein restrict sanctioned persons and entities from having access to funds and property under their control, or from receiving financial services in relation to such funds and property. In order for these sanctions to be given effect to, FIC requires accountable institutions to freeze property and transactions pursuant to financial sanctions imposed by the UNSC resolutions. So the first takeaway in relation to South Africa's sanctions legal framework is that it is very much dependent and tied to the UNSC resolutions, as well as the sanctioned entities and individuals that are embodied in those resolutions. In other words, South Africa does not have a separate or distinct sanctions mechanism that allows discretion to depart from those UNSC resolutions. Targeted financial sanctions provide for financial sanctions only, and the TFS list, which is available on FIC's website, includes the names of prohibited persons and entities. Mechanisms for the implementation of the UNSC resolutions include the publication in the Government Gazette, in terms of Section 26 of FICA, by the Director of the Centre, persons who are subject to sanction measures. I'll talk a bit later about the amendments to FIC, which directly address this aspect. These notices may also be revoked if they are no longer necessary to give effect to the UNSC resolutions. For instance, in circumstances where an individual or entity is removed from the UNSC list, the notice would no longer be appropriate, and the director could then provide notification of the removal or discontinuation of a particular notice. If an accountable institution has a sanctioned person or entity as a client, it is allowed to draw the attention of the person or entity to the relevant sanctions notices. Following such a notice, the director, as I had stated earlier, must from time to time and by appropriate means of publication give notice of persons identified by the council resolution. This means that the notification must be given on an ongoing basis, as and when the UNSC resolution sanctions list is updated. AIs are not allowed to transact with a sanctioned person or entity or to process transactions for such a person or entity. The only exception to this general prohibition is in specific instances where certain permitted financial services or dealings are allowed. This is also dealt with in the FIC Act. So what are the obligations on accountable institutions arising from Section 26 of FICA, read with other sections of FICA related to customer due diligence? They are required to scrutinize their client records to determine whether they have a business relationship with a person or entity mentioned in the UNSC resolutions and by implication Section 26A of the Financial Intelligence Center Act. Although an obligation to scrutinize such clients and business relationships will exist whenever notice is given of an update to the UNSC list, accountable institutions are likely and encouraged to screen on a more frequent basis. This is to mitigate their risk and in accordance with the risk-based approach, where clients pose a higher risk, screening is required on an ongoing and more intermittent basis. Although it is recommended that screening should take place at a minimum during the client on-take process, as mentioned earlier, the risk-based approach, as well as the risk management and compliance program of a particular accountable institution, may specify increasing or lesser degree of screening dependent on the risk profile of that particular client. Section 26 of FICA contains 3 distinct prohibitions against the provision of financial services or economic support to a sanctioned person. Broadly speaking, the acquisition, collection, or use of property of persons or an entity subject to a targeted financial sanction is prohibited. This includes the provision of financial services to those persons. Section 28A also contains a reporting obligation on accounting institutions in circumstances where there is the collection or use of property of persons who are subject to sanctions, the accountable institution is required to report to FIC property in their possession or under their control, which is owned or controlled by on behalf of such a person. This must be done by submitting to the FIC a terrorist property report in terms of Section 28A1 of FICA as soon as possible. It's notable that in circumstances where the requirements for Section 28 of FIC are not applicable or are not met or fulfilled in a sense, that the obligation to report in terms of Section 29 of FICA, which relates to suspicious and unusual transactions, may also find application. And in those circumstances, accountable institutions or individuals are required to report in terms of Section 29 of FICA. So the second takeaway, I would say, in relation to the sanctions legal framework in South Africa is that not only is there a prohibition on transacting with individuals or entities that are subject to sanctions, but there is also a reporting obligation in circumstances where certain red flags have been triggered on accountable institutions and certain individuals. So what happened in the mutual evaluation report of FATF, and how did that implement certain amendments or bring about, catalyze certain amendments to FICA? So in FATF's mutual evaluation report, South Africa was found deficient in a variety of aspects. This holistically led to South Africa's grey listing earlier this year. However, certain of those deficiencies were identified in relation to sanctions in particular. One of the identified deficiencies was that the current framework enabled significant delays in the implementation of UNSC resolutions. In other words, to the extent that there was a UNSC resolution sanctioning a certain individual or entity, the lead time for a notice to be promulgated by the minister in those circumstances was not defined, which could lead to a delay in such a notice being promulgated and taking effect in terms of local legislation. Another is that there was no mechanism establishing a domestic process for identifying designated persons and entities. So the amendments brought about to Section 26A of FICA are as follows. Previously, in terms of the 2017 amendments to FICA, it required the minister to announce the adoption of the resolution taken by the UNSC by notice in the Gazette or in other appropriate means of publication. Following a notice contemplated in subsection 1, the director of FIC was required from time to time and by appropriate means of publication to give notice to persons and entities being identified by the Security Council pursuant to a resolution. The new position in terms of the amendment is that a resolution adopted by the Security Council of the United Nations has immediate effect for the purposes of the Act upon its adoption by the Security Council and the United Nations. So the amendment has done away with that lead time for subsequent local or domestic incorporation of the UNSC resolution into our laws, which has addressed the deficiency identified by FATF, that there could be a delay in the implementation and incorporation of those sanctions on the local front. This is a welcome and necessary amendment, and it ensures the implementation of US sanctions, UNSC sanctions, without delay. Another international trend, which we have seen in foreign legislation, is that international best practice suggests that a strong financial sanctions regime consists of both UN-mandated sanctions as well as local domestic sanctions. This is not the case in South Africa. We have a single system of sanctions, which is heavily dependent on, totally dependent on UN-mandated sanctions. And we do not have, our legislation does not provide for a separate local mechanism. Given our, this is a sort of aspect that will be largely influenced by our political stance and our political policy, as well as our affiliations and allegiances to other countries. So for that reason, it is not expected, and certainly in my view, it is not expected to see a unilateral sanctions regime imposed in South Africa in the near future. Another amendment or ripple effect to the local sanctions regime is the Financial Intelligence Center Directive 8, which was recently issued and regulates the screening of employees of accountable institutions for competence and integrity, as well as the scrutinizing of employee information against targeted financial lists. The FEEC Directive 8 requires such screening to be done on prospective and existing employees. And according to PCC 55, which is the guidance note issued by FEEC, all prospective and current employees must be screened against the targeted financials list as and when it is updated. So this brings home the sanctions framework on a more sort of micro level to the employee-employment relationship with accountable institutions, and screening is required to be undertaken as and when notice is given by the director in terms of FEEC. So for this reason, we see that the requirement on accountable institutions to sanction or to mitigate their risk in respect of sanctioned individuals and entities not only applies outwardly to dealings with third parties or their clients, but now also applies inwardly to their prospective or current employees. So moving on to the last part of my discussion, which speaks to tips, practical tips for mitigating your risk with transacting sanctioned individuals and entities. We see that on a broad scale, and speaking in relation to the FEEC structure and the FEEC framework as embodied in Section 26, practically, how would an entity go about mitigating its organizational risk of transacting with sanctioned individuals and entities? Firstly, it could undertake due diligence on counterparties before entering into any corporate or commercial agreement, specifically where there's uncertainty if the counterparty has been sanctioned or where the counterparty's exposure to targeted financial sanctions appears to be high. In your corporate commercial sense, this would be a component of a due diligence, a greater due diligence exercise to ensure that the proposed entity or individual which an organization intends to transact with is not sanctioned. And then when drafting contractual terms, the counterparty should warrant that they are not a sanctioned entity, and the agreement should provide some sort of cancellation provision to allow for the innocent party to terminate the contract without incurring damages if the counterparty is or becomes sanctioned during the business relationship. And then speaking directly to Directive 8, which is more recent and which the enforcement of which has not happened as yet, given the recency of its promulgation, and which we expect to see from the FEEC in the coming months and years, and I think which is going to be an exciting development in the sanctions space and the money laundering space generally, is that accountable institutions are required to take steps to ensure compliance with the screening requirements set out in FEEC Directive 8, which relates to screening their employees and prospective employees against the sanctions list. And typically that would involve an amendment to their risk management and compliance program to deal with aspects such as sanctioned individuals and employees. And further to that, it would require, in our view, that they ensure that their sanctions policies, employment policies, and any other relevant policy is aligned to address a prohibition on the recruitment and employment of individuals that are sanctioned or entities that are sanctioned. So those are a few practicalities and tips that can be taken along and incorporated into your organization to accommodate the new changes to Section 26 of FEEC, as well as FEEC Directive 8, which was recently issued, and which we look forward to the enforcement of. That's it from me today, and I think I've covered all aspects relating to the recent amendments to the Financial Intelligence Center, as well as international trends and tips, and happy to address any questions that may be of assistance.
Thank you so much, Krevania. A round of applause, everyone, for that lovely, lovely presentation. We really appreciate it. If you have any questions for Krevania, please do. The chat is open as well for those online. I'll be very happy to facilitate. But if there's anything from the floor, I'm happy to take the question and pose it to Krevania accordingly. Please do ask questions, because if you don't, I will.
Our sort of relations with Russia from a South African perspective. Krevania, how do you see that playing a role in our in sanctions going forward within SA?
This is the type of question that we all anticipate and seek to avoid.
Yes.
As lawyers. But having advised extensively on this aspect in the last year and pursuant to the Ukraine invasion, it's clear that South Africa has a certain political stance and it has certain political allies. And as I mentioned earlier, and I perhaps had said this too discreetly, but a sanction is definitely a economic weapon, and it is intricately and intimately tied with a country's political stance. And so for that reason, it is unlikely in circumstances where a country has an ally that it would implement measures to sanction individuals and entities that are hailing from its ally or that are adopted on a wider scale, for instance, by the European Union or other sanctioning bodies or sanctioning regimes. A country is not likely to adopt similar measures where it does not suit the political will of that country. So I hope that answers your question.
All right. Thank you so much, Krevania. Well, I've got one from my end, if there's nothing on the floor, actually, and it's really around the evolution of legislative framework. Having moved from the rules-based to principle-based. In your view, from a particular reference to sanctions, how are we actually doing? I know compliance officers would actually need to provide some assurance in that, but from a legal perspective, is that quite some substance for us to be moving towards and making sure that we are aligned with, curbing financial crime from a sanctions perspective?
Thanks very much, Tanile. I think you raise a valid question, and we've seen the evolution of the sanctions legal framework, first in the amendment to FICA in 2017, and now to the more recent amendments earlier or late last year. And I think a good benchmark to ascertain our compliance would be to see, what has the FATF's mutual evaluation report said.
Yeah.
And it has indeed been critical of certain aspects, especially in relation to the domestic mechanism of adopting a UNSC resolution and the time delay that's implemented in that sense. And it has taken steps now to address that by introducing the provision of there being an immediate adoption of those UNSC resolutions as opposed to allowing a time lag.
Yeah.
So that, in a sense, is definitely aligned us and brought us into the realm of better best practice internationally. And I think that's a stepping stone. And, seeing as though we have our UN membership and our the fact that we're abiding by these UNSC resolutions, I would say that we are more or less internationally aligned. The next step to follow, other jurisdictions, first world jurisdictions, would be to have our own sort of, discretion and our own local sanctions regime that is not dependent on the UNSC resolutions, but can, from a South African perspective, promulgate sanctions. Whether or not that will happen or there's a political will for that to happen is a different question. And that will be dependent largely on our foreign policy and our allies.
Awesome. Thank you so much. Really appreciate your time today. Thank you, Krevania.
Thank you very much, Tanile, for the opportunity, and have a great conference, everybody.
Awesome. Thank you.